my topic is the effect on so-called equalities legislation on the church. The question is both cultural and legal. From the legal perspective, I'm more comfortable framing the question as what is the effect of so-called equalities laws on freedom of thought, conscience, and religion, or what happens when there becomes a clash between so-called anti-discrimination legislation and freedom of religion. And to answer, we need to ask two fundamental questions. First, why does religious freedom matter? Second, what are the legal threats inherent in anti-discrimination legislation? So let's turn now to the first question, and that is, why does religious freedom matter? Now, from a spiritual perspective, this is a pretty obvious question. Freedom of religion is the only right that recognizes the transcendent, the relationship between man and God. However, from a legislative perspective, it's not such an easy question. We have to delve a little bit deeper into the policy behind it. Now, what is the hook that should require governments to regulate this particular freedom? Yes, the relationship between God and man is fundamental, it's primary. As Paul Tillich would call it, it's our ultimate concern. But there are lots of relationships in our lives that the government doesn't pay attention to. We can have a best friend, an incredibly intimate friendship, but the government doesn't come in and regulate that. So why regulate the relationship between man and God? So my belief is from the government perspective, the policy perspective, that one of the hooks that makes it so important to regulate religious freedom is the aspect of what religious freedom does for society, the good that it provides for society. Religion provides social services in countless realms, whether it be homeless shelters, adoption agencies, after-school programs for children, hospitals, schools, universities. People of faith also give more to charity per capita than other people. So it is a substantial amount of good being done for society through religion. Now, collectively, the social services provided by the church are essential, an essential good for a healthy democratic society. The burden on government to provide these services to its citizens would be overwhelming. Further than that, religion plays an incredibly intimate role in our lives. It is essential to the makeup of who we are, how we live our lives, and so there's a government interest there as well. And historically, there's obviously a lot of reasons to protect religious freedom. We look at religious freedom when combined with other rights. Freedom of association, for example. What happened here in Poland with Solidarność, when you had the combination of freedom of religion with freedom of association and freedom of expression. It brought down communism. We have the intimate, the personal. We have, I guess the debate between Viktor Frankl and Sigmund Freud, where Sigmund Freud said that when you take anyone from society, no matter how much money they have, whatever their profession are, no matter how they were raised, if you take everything away from them, they will become brute animals. Well, Frankl said that his experience in the concentration camp, where that was exactly what happened, proved otherwise, and that there came from that the concentration camp saints, the people who actually flourished when everything was taken away from them. And really, we can't divorce that from the relationship of man and God or woman and God. And of course, when we look at the foundational documents of this generation, the documents that came after World War II, the Universal Declaration of Human Rights, the European Convention of Human Rights, these aren't documents that were created within a vacuum. What had happened leading into World War I, and particularly World War II, is that states had seized the reins of power. They had decided that they knew how they were going to move culture forward into a better, braver world. And what happened was the atrocity of the Holocaust, which you'll get to see firsthand this afternoon in Auschwitz. So what these documents did, and I believe they're natural law documents, was to say we need to invest the rights where they belong into the individual and take power away from the states. Now the European, let's move on to the second question of the legal deficiencies in so-called equalities legislation. The European Court of Human Rights utilizes a three-pronged test to determine whether a state action is in violation of the European Convention of Human Rights. The first question the courts ask themselves is whether the impugned action was prescribed by law. Now, European law demands that any legislation must be defined in such a way that it be clear, foreseeable, precise, and accessible. So that means that when there is a law, a person should be able to govern their actions appropriately, knowing what that law is in foresight and knowing how to react to it. Furthermore, states cannot act with an unfettered discretion to implement that law. Both with the concepts of sexual orientation and gender, we see that they fail to meet this very threshold as they relate in the way they are defined by the homosexual agenda to the concepts which, both concepts as defined by the homosexual agenda, are completely fluid and malleable. Now, the Yogacarta principles, which is kind of the Magna Carta for the homosexual agenda, it was put together by so-called experts in Indonesia, and it's been, I guess, shopped around to various intergovernmental bodies, including the Parliamentary Assembly of the Council of Europe and the Parliamentary Assembly of the OSCE. They've failed to implement it yet in any meaningful way, but it's out there and it's frequently cited. And the terms are becoming more and more used among politicians and policymakers. It's something to be worried about. And these principles define, for example, sexual orientation as each person's capacity for profound emotional, affectional, and sexual attraction to and intimate and sexual relations with individuals of a different gender or the same gender or more than one gender. And gender identity as each person's deeply felt internal and individual experience of gender, which may or may not correspond with the sex assigned at birth, including the personal sense of body, which may involve, if freely chosen, modification of bodily appearance or function by medical, surgical, or other means, and other expressions of gender, including dress, speech, and mannerisms. So the definition of sexual orientation is dangerous because it equalizes all sexual relationships, divorcing sexuality from its biological purpose, which is procreation, and from social responsibility. And the question of social responsibility I'll get back to later, because this is one of the major issues that it's really become too taboo to talk about, but the statistics, the social science, and the medical science is quite shocking. Now, the definition of gender identity is also enormously flawed because it's completely subjective, ignoring the basic objective biology and the reality that we're born into a certain gender. So, and we see this increasingly with the question of public bathrooms. Now, if I feel like a woman one day and I walk into a women's washroom, in most countries in Europe, I'll still get arrested. Not in Sweden, just to let you know. So I had a wonderful experience in the main shopping mall in Sweden where we went to the bathroom and everyone went into the same door. It's just something that it just doesn't feel right. It feels like, you know, when I was in university and they had women's studies group and they said, this is what the world should look like. Sweden somehow has implemented that. I love Sweden, though. I do love Sweden. I go several times a year. So a major problem has been that there's been intentional confusion that intergovernmental bodies have used in not defining this term. It's to the benefit of intergovernmental bodies and really to the homosexual agenda to keep these terms fluid and malleable. So for example, when they were drafting the Treaty of Amsterdam, the European Commission rejected a proposal that would have separated the question of discrimination against an individual because he self-identifies as homosexual and homosexual behavior. Now, that seems like a semantical issue, but the reality is that this is a significant problem. Because on the one hand, discrimination based on the fact that someone is self-identifying as homosexual is one thing. Someone comes in for a job interview, I learn that they self-identify as homosexual, and I say, because of this fact, even though you have all of the tools to do this job, you're not getting the job. Now that is discrimination. What you have on the other side is now employers, service providers increasingly are being forced against their conscience to provide services to promote the homosexual lifestyle. Now that is a huge, huge difference and one that should not be happening in Europe. And cases abound, primarily from the United Kingdom. And I'll just go through several of them because I think they're important. Two of the fundamental ones that we've heard come out of Europe because they were recently, last January 15th, ruled upon by the European Court of Human Rights. The first is that of Lillian Lidelli. Lillian is a marriage registrar, was a marriage registrar in Islington County in Council in London. Now, she was one of 20 marriage registrars, so it wasn't a small office by any means. She had been in her position more than a decade before she had heard rumblings that the UK was going to legislate same-sex partnerships. So she had gone, as a Bible-believing Christian, to her supervisor and asked for de minimis reasonable accommodation, saying that this would make just a tiny part of my job. We've got 19 other registrars. Let's schedule around it. That way my conscience is fine. I'm not discriminating against anyone because no one has specifically asked me for this service. It's called the concept of reasonable accommodation. It's used in a lot of jurisdictions. It's something we've been desperately trying to get into the convention law in Strasbourg. And despite the reasonableness of her request, despite the fact that freedom of religion is supposed to be a fundamental and substantive human right, which can only be interfered with in situations where it's necessary in a democratic society, that's what the court says, and in a means that's proportionate to a legitimate aim. Now here, there was no, the interference was just de facto. There was no even attempt to facilitate her religious rights. And so the case went to Strasbourg. The companion case to that was Gary McFarland. Now, Gary was a former lawyer, became a counselor and wanted to specialize in psychosexual therapy. Again, Gary was a believer who had issues with promoting homosexual behavior and asked the hypothetical question to his supervisor. So it wasn't even, again, it wasn't the fact that clients came to him and he rejected them, but he asked the hypothetical question, can I not perform psychosexual therapy for same-sex couples because it is against my faith? Now, what ensued was he was let go for, I believe it was gross misconduct. And gross misconduct in terms of employment law in the UK, it basically, if you punch your boss in the face, if you steal money for him or take his car for a joyride, that's gross misconduct. Asking a simple question about whether you can opt out of this certain therapy is not gross misconduct. Nonetheless, he's now blackballed from the profession because this is a huge black mark on his record. Now, therapists, they refer all the time. If a therapist or a medical professional is going on vacation, they refer to another physician. If there's a personal conflict, if it's a family member, they refer to another physician. Referrals happen all the time. This would have been another easy circumstance where freedom of religion could have been respected simply by referral. There would have been no discrimination. No client would have even known that there was an issue here. Yet they decided to release him from the profession. The Strasbourg court, unfortunately, in my opinion, dropped the ball on this one. What they ruled was that within the margin of appreciation afforded to the member states, in this case the UK, that the states were allowed to determine these intimate questions. So it's not a total loss in the sense that if we go to a country that's more conservative, like Lithuania, and the case goes the other way, where religious freedom is protected against sexual orientation, then it would mean, you would hope, judging by that precedent, that that would be within the margin of appreciation as well. But that leaves the question completely open, and it will certainly be revisited within the future as these cases become more and more prominent. And one of those cases, which I'm sure will probably open that door, is the case of Peter and Hazel Mary Bull from Cornwall in the United Kingdom, bed and breakfast owners. And these are cases that I'm sure most of you have heard about, if not all, but they are, the foundational cases. This is a lovely couple who ran a bread and breakfast in the privacy of their own home, and they had a policy based on their Christian faith that because of the sanctity of marriage, they would not let a single bed to a non-married couple, whether it be heterosexual or otherwise. And they used the policy without issue a number of times with heterosexual couples. But then when a same-sex couple came and wanted to use a single bed and were rejected, the case went to court and they lost. They lost a significant amount of money simply for not wanting to let a single bed in their private home to a same-sex couple. So it's remarkable the politics here, that even within the privacy of your own home or providing intimate services as a service provider, that the government now can force you to go against your conscience or bankrupt you, basically. The case of the Johns, a family who was refused to foster children because of their belief that homosexual behavior was a sin. The Equalities Commission came in with a statement that This was a good thing because the children would have otherwise been infected by Christianity. So this is a commission paid for by tax dollars, who apologized later for the statement, but a hollow apology nonetheless. And of course, again in the UK, sorry UK, I was picking on Sweden, now it's UK's turn. But an Anglican diocese was successfully sued for refusing to hire a youth worker who was openly engaged in the homosexual lifestyle. Now, if you want to see a bigger hit, a bigger question of the impact of equalities legislation on the church, that right there is your answer. Now, one of the most existential threats to religious liberty in Europe today is the European Union's proposed Equal Treatment Directive on goods and services. Now, the directive, if adopted, will have to be transposed into the national legislation of all 28 EU member states and will have sexual orientation as a protected grounds for discrimination. Now, the legislation could make cases against Christian service providers commonplace within Europe. What's more is that the legislation is so vague that it can be abused with impunity. For example, the directive introduces the concept of harassment. If an individual service provider refuses a service to someone and that person feels that they've been harassed subjectively, they can bring a claim. Now, what's more remarkable is that the standard is a rebuttable presumption of guilt. So you are guilty until proven innocent. So say an individual, I refuse them a service, they are practicing the homosexual lifestyle, and I may refuse for any number of reasons, many of which have nothing to do with their sexual orientation. But if they feel that my reasoning behind it was sexual orientation, they can bring a claim, and then I have to go to court and prove otherwise, which in a society of rule of law is absolutely ridiculous. What's more is that the directive proposes that third parties intervene and NGOs intervene in the cases to promote the litigation. So not only could I be sued for something that I didn't do because of the subjective belief of the person getting the service, but then a number of NGOs can come in and attack me in that lawsuit, making it completely unfair. And we've seen in other jurisdictions that is exactly what's happening. Now, again, back to the United Kingdom, I want to look at the sexual orientation regulations briefly, because I think there's an important case when you look at the adoption agencies in the UK and what happened with them to see why this is so dangerous to implement the Equal Treatment Directive. We'll start with a brief piece of history. In 2007, the United Kingdom adopted the sexual orientation regulations. Now, in 2007, the same year that the regulations were adopted, there were 14 Christian adoption agencies within the United Kingdom. 11 were Catholic adoption agencies in England and Wales, 2 Roman Catholic adoption agencies in Scotland, and 1 evangelical adoption agency in the UK and Wales. As a result of the sexual orientation regulations, all 14 of these agencies have suffered severe and irreparable consequences. Now, of these 14, several which have existed for more than 100 years and have been credited with placing some of the hardest to place children, 11 of the 14 were either forced to remove their Christian ethos or become secular adoption agencies, and others just got out of the adoption business altogether. So the last one standing, basically, the last one fighting this is Catholic Care in the Diocese of Leeds. Now, to put this in perspective, 2 Catholic adoption agencies in Scotland, the 2 in Scotland, accounted on average for 20% of the adoptions in Scotland each year. 1 out of every 5 adoptions. Of the 11 Catholic adoption agencies in the UK and Wales, they performed 1/3 of all private adoptions. Now, before closing its doors to business, the Westminster's Catholic Children's Society, as one adoption agency alone, provided services to more than 3,000 families. Now, while we will lament the loss of ethos-based adoption agencies because of gender politics, what is equally deplorable is that in the name of so-called sexual orientation, countless children will stay in orphanages or inadequate foster care because of the loss of these adoption agencies. Now, to move from that to a little bit of controversy, if we can, is it possible to get it's impossible. Okay, that's all right. So I had a PowerPoint presentation, And it was really to show what I see as the underbelly of the homosexual agenda. And this is a difficult talk to have because there's a lot of sin in the world, a lot of sexual sin, adultery, homosexual behavior, sex out of marriage. There's a great number, addiction to pornography. There's a great number of sexual sins. This is one of many. And it's one that we are forced to talk a lot about because it's the one that is affecting religious freedom the most. So I often am labeled as homophobic for bringing this topic up, and I think that's sad because in a democratic society where we, treasure pluralism and freedom of expression, this should be something that we can openly discuss respectfully. Instead, the mere bringing up of this topic is controversial, and people are labeled as homophobes, even for addressing the question of same-sex marriage. So I'm going to try and work from my head what these PowerPoint slides were. So the first one, you could open it up, sure. All right. Basically, it was the main slides were I had taken photos from the Gay Pride Parade in Prague last year, which I think show a side that we don't see anymore. When we used to think of gay pride parades, we would think of fairly scandalous things, and in many jurisdictions, in many countries, that's still the case. So you had, children watching from the sides, where literally men in dog collars carrying other men who were naked, who would have been arrested in any other capacity, were walking through the streets of Prague proudly. And then, for the first time ever, the pedophile lobby in the Czech Republic marched in the same parade. And what was remarkable about it was you had the American ambassador to the Czech Republic, as well as a number of other ambassadors, marching in the front of this parade, as if this was something to be glorified. Now, one of the biggest things that we don't talk about is the health risk, particularly of male-to-male sexual contact. And I had several slides, one from the CDC, the Center for Disease Control in Atlanta, it's remarkable when you look at it. And that one I really wanted to show you because it's an image, that really sticks with you. When I just say it, it's not as powerful. But it was looking at transmission of HIV/AIDS in different cohorts. So at the bottom of the chart, you had every other cohort, which was in blood transfusion, drug use, etc., which all have been declining steadily for a number of years. Then way at the top, you had male-to-male sexual contact. It is, and we don't talk about it, it is growing at an epidemic rate. 66, so this was from both the CDC but also the Food and Drug Administration, that whereas they estimate that only 2% of American males self-identify as homosexual, 66% of all new cases of HIV/AIDS happens in male-to-male sexual contact. And that number is actually more because when it comes to intravenous drug use, they can't determine what the cause was, so that number is actually higher. 77% of all cases of HIV/AIDS transmission happened through male-to-male sexual contact. Another statistic, which is why the FDA, in a controversial move, refuses to accept blood from any person who's ever practiced male homosexual sex. Because it's just a remarkable statistic. 2% of the population making up 77% of the cases. What's sad about it is that the greatest number, there's been a 24% increase in HIV transmission among homosexual males between the ages of 13 and 22. I think that's the most troubling statistic there. Divorce rates in Scandinavia, where they've had same-sex marriage longer than other jurisdictions, they have estimated it to be up to 167% higher than among heterosexual couples. Domestic violence, and this statistic is from the American Bar Association, which is very pro-homosexual agenda, says that 82% of cases in the United States that have been referred to a certain domestic violence agency happen among same-sex couples. They've also studied that the more violent crimes among cohabiting couples happen among same-sex couples. So we shouldn't kid ourselves that this is a lifestyle that's worthy of putting out in the media as if it's the best thing since sliced bread. Now, there are consequences to legislating homosexual behavior, and one of them is saying that this lifestyle is okay. We see it in the media all the time. Celebrities going out, politicians going out and glorifying this lifestyle. But there is this other aspect of the lifestyle. And when you legislate on these questions, and especially same-sex marriage, and when you shut the debate down on same-sex marriage, and that really opens the door, because once there's no debate, it's almost a given that it's going to be an eventuality that your country is going to adopt it. Then you start having same-sex adoption. And you have children entering into homes where there's increased domestic violence, where there's increased divorce, where there's increased infidelity, and where those families are not family-centered. I mean, the definition of marriage is that it's permanent, exclusive, and family-centered. We've redefined, when you hear this term, redefinition of marriage, what is the redefinition of marriage? It is that we're no longer family-centered, we're no longer permanent, and we're no longer exclusive. It didn't happen with same-sex marriage. It really began with no-fault divorce, where fathers weren't staying with their families. But the nail in the coffin, the nail in the proverbial coffin, is same-sex marriage. Social science is beginning to develop. It's not out there yet because it's still a very new experiment, but it's something to be worried about.